Good morning, everyone. It's great to be here this morning talking about one of my favorite topics. As Clay said, our firm, Mike, Oliver, and I are partners of Oliver and Grimsley, handling patents, copyrights, trademarks, technology, and business law matters. So this morning, we're going to hit one of those topics, and that's trademarks. So first, what is a trademark? Because trademarks are one of the IPs out there. You have patents, which are your inventions. You have copyrights, which are contents and original works that you create, whether it's books, software, artwork. And you have trademarks. And a trademark is a word, a phrase, a design, or a combination of that's used in connection with a good or service, and it identifies the source, that identifies you, the business owner, of the goods and services, and it also distinguishes your goods and services from other parties. So, for instance, trademarks they're a part of our daily lives. Whether you go into a restaurant, you're buying food, a coffee, computer software, you're seeing trademarks out there. So as a business owner, you ask yourself, why should you care about these? Your trademarks are source identifying. They connect the customer with who you are. So if you think about it, your trademarks really hold power in your business. They allow you to stand out from another competitor or someone related in your field. And they also help customers have a connection very quickly with you through your trademark. So, and if you think about your day-to-day activities that I mentioned, from the foods you eat, the restaurants you go to, the cars you drive, the coffee that you buy, software that you use, you look to that name for the reputation. You look to the trademark to figure out, oh, this is a Nike tennis shoe that I want, or I want that iPhone, or I want to download this particular app. You're looking for that name because that name identifies who the owner is and distinguishes them from another entity. So one of the reasons why the trademark is very important, and you want to be able to build it and protect it, is you don't want to have other businesses basically palming off of your blood, sweat, and tears that you've put into your business, or that you're putting into your business to build it and get it started. So you want to prevent other businesses from causing confusion by using a similar mark as yours. Similar business name as yours, or there being some type of false affiliation. You also want to keep other businesses from diluting your brand and using your name. So there's steps that you can take in the beginning as an entrepreneur, or even as your business is ongoing and you're coming up with different product lines that you want, whether it's clothing, supplements, pharmaceuticals, what have you. You want to, at the onset, start to consider, what name are you going to use for this product or for this business? And is this name available for you? And then what can you do to build it and protect it? Okay, so next slide. A question that I get a lot is, do I have to register a trademark before I can use it? And the answer to that is absolutely not. The use of the trademark establishes your rights. So the moment you start using your trademark, or you put your shingle out and you start operating your business in that name, at that moment, you start creating trademark rights. Start building them up. And what that is called is a common law trademark. And you actually can enforce these rights too. But with a common law trademark, your protection extends to the geographic territory and where you use it. So your customer base. If you operate in Maryland and the surrounding states, that's where your protection will lie. So for instance, if you're operating your business, you're moving along, a couple years later, someone in Texas or California starts operating with similar business using your mark, your protection does not extend that far. Your protection extends only in the area where you've been. And in fact, if you go to Texas or you go to California, well, now you're infringing on their rights because their protection is there. So you need to be mindful of your boundaries. So now you can use the TM symbol too. Despite the fact of not registering, a TM symbol is permitted. The registration symbol, though, that you see, the R with the circle, you may not use that unless you have a federal registered mark. Next slide. Okay, so now that you know that you don't have to register your mark, should you register your trademark? The first question that you ask yourself are you going to operate over state lines, or do you intend to in the near future? If you are, for instance, just operating in Maryland, you have a brick and mortar store, your customers are only in Maryland and aren't going to be going over state lines. You're not going to be doing business in DC or Virginia. Then you could look more so to the common law use, or there's actually state trademark registrations, and you could register in your state. However, and we see this more and more now, particularly with the internet, if you are going to be operating over state lines, so your goods or services that you're providing, you're selling goods to consumers in Virginia or DC or anywhere in the US, you will then want to consider a federal trademark registration. And there are numerous benefits to having it. Your first benefit is, as you see on the list, nationwide priority rights. So the example of what I mentioned before, where you're, as a common law user, where your protection is restricted, with a federal registration, you now have nationwide priority. So if that subsequent user, this is to subsequent users, if that subsequent user starts a business in California, now you have an opportunity to put them on notice that you have a federal trademark registration. You may not be able to force them to stop until they start to come into the same areas, but you've now put someone on borrowed time, which usually businesses don't want to be in. So huge benefit right there. Your second benefit is this is also a public notice of a claim of ownership. When you file a trademark application, it is listed on the PTO database. So if someone else, for instance, is starting their business in your field and they want to use your name, when they do a search, your name will come up. And that is a huge deterrent effect. And that is priceless because you don't even see how many people may have considered using your name and changed their mind upon seeing that there is someone who already holds a trademark.
I do have a couple questions here, if I could interrupt for a minute.
Okay.
I'm sorry, I had to step away for 1 second, so I'm not sure if this question was asked, but what if your business is online and therefore national?
If your business is online, then definitely federal registration is something that you certainly want to consider, because you have, by being online, you are already going over state lines. You're probably providing services to customers in other states, or goods, or if your online business you're in the business of providing information itself online, well, that is interstate commerce right there. And you'd want to look at federal registration.
Okay. That was Michael's question. And then Rolanda asks, I'm curious. I have 2 travel agent friends with the same exact business name. One is in New Jersey, the other is in Florida. The clients cross state lines. Does one have the right to name over the other?
That gets very interesting. And we see this sometimes when entities come in, they want to file a registration for their mark, and then they see that there is someone already out there in another state. And a question that you have to start to look at is, who started operating first? And there's a lot of factors to look in to who started first, where's the protection of one person? Can you file an, are there customers, starting to confusion to be involved? And that gets to be a pretty deep question there, because you'll look to, does one have a federal registration? Does one, not? This is a lot of questions that was just posed that we deal with day in and day out. And those are good questions that we could talk online, because they start to become very fact sensitive as talking to where are they operating, what are they doing, and how are the customers interchanging with each other. Okay. All right. So next, if you have your mark registered, it's also presumed to be a valid mark. And that is important in the event you find that there's a business out there that is using your name, and you're worried about the confusion starting. You send a letter out to them, and when you send your letter, you note already that you have a federal trademark registration and what that registration number is. Because if you're registered and you're registered on the principal register, which is where strong marks are, your mark that's evidence that you have a valid mark. Another benefit is you can use the registration symbol. As I noted before, you can use the TM if you have an unregistered mark, or if you filed your application but it's not registered yet. But once the mark's registered, you can use the R symbol. And I suggest that once you have the registration, you've put the time and effort into it, use that R symbol in your marketing materials, on your website, in your business cards. Make sure that's out there so that when people go online, for instance, and they see your mark, they see that symbol, they automatically know that's noticed that you have a registered mark, and it gets rid of an innocent infringement claim, which can become important from a damages perspective, should you have to go down that unfortunate road of taking action against someone. Another benefit is, and we see this more and more today with the internet, businesses who are operating in the US are moving more quickly overseas and providing goods overseas, providing services internationally. And the use of your registration can be used as a basis to start obtaining international registrations too. You can record your U.S. registration with the U.S. Customs and Border Protection, which will help in the event that the business that you're involved in, you can prevent infringing foreign goods from coming in. And then the last benefit that I think is very extremely beneficial and valuable to trademark owners is, if you use your mark consistently, you use your mark correctly, and you renew your trademark registrations during each of the renewal periods, that registration can last indefinitely. So as your business continues to grow, the time and effort that you put in to investigating the protection of your trademark at the beginning will continue to last as long as your business lasts, provided you do those steps, using it consistently, correctly, and renewing your registration when you're supposed to.
Kim, we have a couple more questions.
Okay.
The first from Miriam Rose is, what is the difference in using the R from the TM symbol, which I think you just kind of explained, but.
Yes, I can do a quick recap. TM symbol you can use as a common law owner, which means you have not registered your trademark yet, or if you have a pending application, you can use the TM. Now, you'll see some businesses who may have a registered mark and they just hadn't changed it over to the registration symbol. But the registration symbol can only be used if you have a federal registered mark.
Okay. And then the second question is, what type of trademark should I use for my class content that I create? I have it in-person and online classes. So just a federal trademark to cover everything.
If you are doing online classes, it sounds like since you are operating online, that you could likely look towards a federal registration because you're providing your services over the internet. The one thing that I would want to talk to is on a case-by-case basis, like what are the clients, or who are the clients, where are they coming from? Are they strictly state-based or not? And do you see yourself, which will actually hit a little bit later in the presentation, do you see yourself having the potential of having clients over state lines in the future? Because you could still preserve a federal registration in doing that. But it's a good question when you bring up online use. If your business is solely an online business, like online fitness classes and so forth, because it should be, I'd want to double check, but you should be able to be covered under interstate commerce because of the fact that you are providing your services online.
That's
Okay.
it. Oh, wait a minute. Oh, Miriam says thank you. And I'm sorry if I mispronounce your name, Nicole Bob says yes, Maryland, and possibly grow to DC. So
Yes, then you would want to look into a federal trademark registration because having customers in DC is in fact interstate commerce.
everybody says thanks. So we can move on.
Great. All right. So let's see the next one. So now you've decided, okay, you do want to look into protecting your trademark, filing a federal trademark application. What steps should you take in choosing your mark? And now this is actually the case, even if you would decide not to register your mark, you really want to look at these two areas: the strength of the mark, the strength of the name that you're choosing to use for your business or your product lines, and the availability of the mark. So we'll hit the strength of the mark next. So that's the next slide. There are 4 types of trademarks, and I've listed them from the strongest to the weakest. And when you are looking for a name to set yourself apart from others, you want to look for a strong name. So your strongest are your arbitrary and fanciful marks. And so what are those? Your arbitrary marks are ones that are a company has taken a name and they've used it in a manner that is unlike its ordinary definition. The classic example is Apple for computers. If someone had, they called their business, the Apple store for selling fruit, that not strong, but Apple for a computer, entirely different definition. Another example would be, say, Amazon for online book sales, Domino's for pizza. They're not names that are normally associated with the definition of the word or the goods. Also, fanciful marks are strong, and these are ones that are entirely made up words. Exxon, Kodak, words that a business has just made up to start in connection with their business. Those will be your strongest ones and the ones that have the strongest enforcement protection. Your next line, and these are also strong marks too, are your suggestive marks. And a suggestive mark is one that when you're thinking of the name, once you add like a step of imagination to it, the consumer can figure out like, oh, this is what the goods and services are. A couple examples of this would be Roach Motel for insect traps, or a Glass Doctor for cars, fixing the windows that are in vehicles or fixing the windows that are in your home. Once you hear it and you see the goods and services, you're like, oh yeah, I get the connection there. So there's some cleverness involved in there. And those marks are source identifying, they're distinct, and they're strong marks as well. Your next line, and we fall into this, we have lots of discussions with clients on this, is descriptive marks. Some clients like to have some type of descriptiveness in their name so that a consumer can immediately see, what the good or service is. However, you cannot protect, they're much more difficult to protect a descriptive mark, because what a descriptive mark is when you hear the name or see the name, you immediately have what a product, a feature, or characteristic of the good is or the service. And so if someone had the name like Burger Boys, or Burger Bar for a restaurant or for a bar, protection in the name burger alone would not be fair to other third parties if you're trying to claim protection in the name burger. So a couple examples of descriptive marks would be, and actually my team was having fun, just pulling up some names, but like, Burger Bar, or if you had something like Pup Step, for your steps, like steps for animals to go up and down, that would be considered a descriptive mark. Now those, I could probably do an entire webinar just on, descriptive marks alone, but those are ones that are much more challenging to protect. And you may see some marks out there in the world today that sound pretty common and descriptive to you. They may have reached that level through a long amount of time of use and getting out there continuously to consumers, to the point to where their mark has now acquired distinctiveness. And so now it's become a stronger mark through just at least 5 years of use. And getting your name out there to where when consumers see the name, they recognize it with you as opposed to someone else. Then your weakest form is a generic mark. On a generic mark, it doesn't matter how popular this name becomes, you can't protect that. It cannot get registered at the U.S. Patent and Trademark Office. And an example of a generic mark would be, say, for instance, you sold wine and the mark for your store was called the wine store. That would be considered a generic mark. Or an example I like to give is, say you created your own luggage line. And when thinking of the name of the mark for the luggage, you decide just to call it luggage. That is not going to be protected because you've just picked the name, of the common genus name of the product itself. So why is the strength of the mark important? One, you want it to be strong enough so that you can actually get it registered on the Patent and Trademark Office, on their principal register if possibly. You want it to be strong enough so that you can stand out from other people. So when a consumer sees your name and your mark, they can distinguish you from others. And the weaker the mark is, the harder it is to enforce if you find that someone is infringing against you. If you've chosen a name that is descriptive, they may be able to make just mild changes to that mark to also be able to use something similar to you. Okay, so now we've gone through the strength of the mark. The next area you want to look at is when you're choosing your name. And again, this is the case if you're registering or if you're just using it without registering it. Is that mark available? You need to search the marks to make sure that the mark that you want to use is not already being used by someone. And when you are searching to make sure a name is available for you, you are not looking at just, is there an identical mark as yours, but is there a confusingly similar mark to yours? So, just making a name plural, adding an S at the end of it, does not separate you from someone else. Sometimes just the changing of the vowels, that would still be considered a similar mark. Trademarks that have equivalent spellings or sounds could also potentially be problematic. For instance, take the word skate that's spelled S-K-A-T-E, but then the word skate that is spelled S-K with the number 8. It still sounds the same. So when consumers hear that, they may get confused. What entity, what business am I looking at? And you also want to keep common law users in mind too, because you would not want to register a mark. And there's a common law user out there right in your backyard that's going to, one, oppose your trademark application, or two, bring a claim that you assert that you're actually confusingly similar with theirs. One of the, a tough spot to be in for a business, for instance, is start your business, get your name going, you're out there online, you're getting your marketing materials out. Say 2 years have passed and you've built up your business, and now you get hit with a cease and desist letter from another company. And when you start taking a look at it and you're taking a look at the facts, and you see, oh my God, they're there first, and we're right in the same area. And now you're fighting one with another company, and you're now trying to phase out your name, to start and find a new name, make sure the customers that you have, get used to the new name as you phase out and move over to a new one. And that can be very frustrating and very costly to you. So you want to search ahead of time before you launch that new name or launch that new product. And although searching for a trademark is not required and it is not mandatory, knowledge is not a requirement to be found to be infringing on someone. So you can't just say, well, I'm not going to search, so I don't know. And if they come back, I'll just say, sorry, there's knowledge isn't a requirement for infringement. Okay, so next slide. Now, so you've decided you want to register your mark. You've picked a strong mark. You've searched it. It's available. Now what? Now it's time to file your trademark application. And another question that I get a lot is, do I have to be using this mark before I can file the application? And the answer is no, you do not. If you are using it, we file what's called a use-based application that states when you started your use, and we provide evidence to the Patent and Trademark Office of what your use looks like. But the beauty of this, of what I love for businesses, is there's also something known as intent to use applications. So say you're getting your business started, but it's going to take you a little bit of time to get everything together. Perhaps the product line, you're doing a clothing line and you are looking for what materials that you want to use and what it's going to look like, but you know the name that you're going to have. The Patent and Trademark Office will allow you file an intent to use application, and you have technically, after the mark has been approved, 3 years to show interstate use and get your federal registration. So you've basically kind of put a placeholder in there once the PTO has approved you to use your mark when you have interstate commerce and you've gone over state lines. And that is very beneficial, because take my clothing line incident. What if you've waited a year to get everything together, and then you've got it, you've hit the shelves, and you go to file your trademark application only to find that 6 months ago, somebody else already filed for that name in your field? That's extremely frustrating. So the intent to use application is a perfect placeholder for you. Next question, how long does it take? It's longer now post-COVID. It used to take about, if everything went smoothly, about 9 months to a year to get your trademark registration in place. And the reason for that is once you file your application, it would take about 3 to 6 months before the Patent and Trademark Office assigns an examining attorney to your file. And so it takes some time just for them to pick it up and look at it. Since COVID, the time has taken much longer, and we have seen it take 8 months on average, if not more, for your file to get assigned to someone now, which makes searching your mark and having your eyes wide open even more important, because it could be a while before your mark gets registered. Another thing that is great about filing your application, though, is the moment you file that application, which is, much faster, it can be done in a matter of days to a week, is when you file that application, that date of filing is public record. And that is noticed to everyone that your mark, your priority actually begins as of that date. So you may have filed an intent to use application on, say, February 1, but someone else starts to use the mark in May. The fact that you filed an intent to use, that gives you a priority date right there. That's very important. So the filing process, thankfully, is much faster than the registration. And you might get hit with some snags along the way. Once your application is picked up, the Patent and Trademark Office may say, we need to just make a minor change to your identification. We think you need, they may bring up some substantive arguments against you, like if they think your mark is descriptive, and then you need to kind of go back and forth, and, fight with the PTO a little bit. So it can take a little bit longer. But if all goes smoothly, it will take nowadays, I say at least a year or a little bit more before your registration actually comes through. And then how much does it cost? The Patent and Trademark Office has filing fees, and they range, you pay basically per class. So let me take say you're in the business of a window manufacturer. You're going to file one class for the manufacture and sale of your windows. If you have an online store and you want to say that you have like online sales of this, that's a second class. Many times clients will look to their primary core. So if you're selling windows, you want that class for the sale of windows. But other you have the opportunity to file in to hit all your forms of protection too. If you have a brick and mortar store, primarily actually if you have an online store, many businesses want to file for that class for the online retail sales as well. If your business is one where you're providing information, say you're providing information online in the field of nutrition or health and fitness, you're going to want to file in that class too for providing information. So it can start to build up. Many times though, you want to at least, particularly if you're starting out on a budget, you want to hit your core service. And most businesses file in obviously one class, and that fee is $250 to $350 per class. And a number of businesses will find themselves filing in two classes. So, you have your costs there. You also have to think too, when you're doing your trademarks and you're looking at them, this is an investment that you're putting in, because not only are you filing, you actually want to have someone assist you in choosing your mark and making sure that mark is available. And those professional services, they actually range widely, and it could depend on what state you're, in. So, the firms in that area, if you're working with an entity that's helping you file your trademark, or if you're working with an attorney who's helping you file your trademark. And it can be tough to get that information. I was looking online yesterday just to try to find what would be an average cost in today in the US. And I found there was a survey that was done by the American Intellectual Property Law Association back in 2000 and just a few years ago, 2019. And the cost range was in around $2,400 in looking at everything of, is your mark available? Is your mark strong? What type of issues could you run into? And then you're filing your application. So there is a bit of a range out there. But The core cost with the PTO is your $250 to $350 per class for filing. And then once your application is filed and say your mark is registered, you make it through to registration, at that point, you have your trademark, you're good to go for 5 to 6 years until the time comes that you have to renew your mark. And at that time, it's just a few $100s to renew it. And then you will renew again at your 10th year. And again, it's just a few $100s to renew it. And every 10 years after that. So your investment is in the beginning. But after that, your mark is going on indefinitely, as long as you use it correctly, and you renew your mark when you're supposed to. And another thing, and I don't have this on my slide, but the moment you file your application, we're finding we need to warn clients about this. You will find yourself getting hit with scammers. And some entities, they're not associated with the Patent and Trademark Office, but you will get information in the mail that looks like it's from the Patent and Trademark Office. As we'll have a client that'll say, oh yeah, you filed our application last week. Thank you. I noticed I've got this notice now from, the PTO office, and it says I need to pay this fee for $1,000 for, this. And we were like, no, hold on. You have to be very careful with that. There's lots of mail that you could receive. And the trademark office is now even warning people that there are phone calls coming in from hackers pretending or looking like they're coming from the U.S. Patent and Trademark Office, but they're not. So be mindful of that. And one thing that you can be assured on, though, is if you have an attorney that's filing a trademark for you, and they list themselves as the attorney of record and the correspondent on your application, all official forms of communication from the Patent and Trademark Office goes to your attorney. And then they can contact you and let you know what's going on. So when you get something in the mail or you get a phone call, that's a red flag. Something is wrong, because the attorney of record who's listed on your application should be the one who is getting communications from the Patent and Trademark Office.
And we have, oh, I'm sorry, finish your thought here. And then
yeah, I just real quick too, with these scammers, they continue, not just when you file your application, but we've had clients call us and their renewal window for their application doesn't even open for a year, but they're getting notices and they're panicking because they're getting notice saying your registration is expiring next month, and then they call like, what's going on? And we pull up their mark and we assure them, your mark isn't even subject to to be renewed to even open up for a year. So you have to be mindful of those little scare tactics that are going on too.
We have not a question, but a comment back from when you were talking about naming your trademark. Rolanda says, a little fun fact, the Avenue clothing store tried to stop the use of the Avenue at White Marsh. In a previous life, I worked for an attorney who successfully defended the use. The rest is history. So that's a good example of what you were talking about.
Exactly. I mean, and this happens. I mean, you find yourself on either side. You could be using your trademark, operating your business, and you will get a call from someone who they're actually calling. They thought they were calling the other business. And you're like, wait a minute, what's going on here? Or say this is the part of, say, the name that's confusingly close to your business, their services or their goods are less than par. And then that's starting to hurt your reputation too. So you'll find yourself on that side. But then there's times when you will get hit with someone else who claims your mark is confusingly similar to theirs. And not always, because you got the cease and desist letter, doesn't necessarily mean that they're on the right side. We've seen clients get bullied by larger entities that might be trying to aggressively protect their mark. But at the end of the day, you have the mark you're using is fine, but everything is very fact sensitive. There's no like bright line rule. So you need to sit down and look at the facts in every case. Okay, next slide. Okay, so you now have your registration, and so now what? You've gone through this whole process. Now you want to make sure that you hold on to your registration, and that one of the things that you need to do is make sure you use the mark the way you registered it. So if your mark consists of 3 words, once it's registered, if you take away one of those words and it was, that could impair the rights of your mark. For instance, if you look on their slides, you can see we have a registered mark for the combination, the word, the design, and the statement there. That whole listing is our trademark. If I took away Oliver, and had the registration and it's now just, a G with Grimsley, I've changed that rights. So when I go to try to enforce my rights against someone, or if I go to try to renew my registration, the Patent and Trademark Office is going to look at my use and look at my mark and say, you're not using the mark anymore. You've changed it. So you want to use the mark the way you've registered it. And also, you want to start, like I said before, if you've put your blood, sweat, and tears into getting this registration, you want to use that registration symbol too. And put it on the website, put it on your marketing materials and your brochures so that people can see that you have a registered mark. And then you bypass the rule that, you bypass an argument that they didn't have notice of your mark, which the Patent and Trademark Office will have, the public notice right there. But having it online can help you if you're in the unfortunate situation that you have to look at damages, and when do damages begin. By using your registration symbol, you can say to the person who's infringing you've seen my mark, it's up on the website. It's not only at the Patent and Trademark Office, but it's in online materials too. Now, another factor that is important in protecting your trademark rights is policing your mark. You don't want to let other people use your mark without your permission. And I'm not saying that you have to go after every single infringer out there. This is kind of, this gets to be a gray area too, and courts hold various views on it. Should you find yourself in a situation where your mark someone is infringing on it, and the consumers are actually getting confused, the confusion is looming large, you should take action to protect your mark. If you let, say, 10 infringers, 15 infringers out there, there's a bunch of people starting to use your mark, and then, infringer, there's 15 of them out there, and infringer 16 comes walking by, and now you're going to start enforcing it. One of the arguments that could be held against you is that you've sat on your rights and you've let all these other people use your mark. So it is important to monitor it, because it can have a negative effect on your registration and your rights should you not take action. And the other thing that I suggest to clients, and it happens, over time, you may have filed for one goods and services in your trademark. You want to check from time to time. This happens a lot when we're renewing a mark, that you can renew, and these are still your core services. But should your business have evolved some, and you're doing some other, you've gone into some other areas, you may want to look into, filing another application to protect the new areas that you've gone into. There is a rule of natural expansion, that courts consider that whatever mark, your goods and services are, that it's natural that you may expand some. But if you start to go into entirely new areas, your trademark might not necessarily cover the new area. So from time to time, it's not a bad idea to just kind of go and look at your trademark portfolio and make sure, are you covering everything that you want to cover? And next slide.
And Kim, while we're switching slides, I have a question for you.
Okay.
Should you trademark course names, or is that just a copyright?
That is a great question. Course names, it depends on how you're using that course name. If it, say that course name is basically the premise of your business, you might want to look into filing a trademark for it. You cannot get a copyright for just a small phrase. What you would copyright would be the content of, say, you wrote an article. It's the content of that article that's protected under copyright laws. But say, for instance, the course that you're doing is all on, a particular type of nutrition. You'd want to trademark, say, the name that you're using in connection with all of those courses. And some people you might find have like a series of courses. And I'm just going to make something up. I'm going to use Oliver Grimsley. I'm going to say we're going to do, the OG courses. And, the OG courses is what would be looking at for the trademark, and each individual name would come under it. But if you find that the only course you're giving is under that name, you may want to protect it. So that's a more sensitive one that we would look at for you. Typically, what you'll find is a business will want to trademark their business name. You don't have to. Business names are not necessarily trademarks, but they can be if you hold yourself out and you use it as a trademark. And then all the services underneath typically don't, unless you have some core services that you want to protect that name. Or say you're giving products, you'll see a name. I'll use cereal, for instance. Kellogg's has their mark trademarked, but then each cereal product that they put out, they have a trademark for that product too. I hope that helps.
Yes, he says, okay, thanks.
Great. Okay. Now, you may find yourself in a situation where others start to ask you if they can use your trademark when promoting their goods and services. And this is something, allowing someone to use your trademark is you're granting them permission. In a sense, what you're doing is you're licensing the right for them to use your mark. You need to be careful with these. They are permitted, and licensing agreements do not have to be in writing. However, it is a very difficult challenge to enforce a license agreement when you don't have it in writing. So if you are going to allow such a use, you want to get it in writing, and you want to be careful about contracting as well, because some careless contracting could hurt your rights in your trademark. So you want the who, what, when, where, when you're doing your license agreements. Who are the parties? What is the mark that you're allowing them to use? How long are you going to allow them to use it? Is it going to be just exclusive? Are you going to let a number of people use it, in which case it would be a non-exclusive license? And very importantly, very, very importantly, is how are you going to allow them to use it? On what goods and services? Because as a trademark owner, showing quality control is a must to have a valid license agreement. You're the owner of that mark, so you should control how that mark is used. Example is, for instance, a bridal shop that was starting to allow the use of their name, to other shops to use their mark for their dresses. And they had written license agreements in place, but they did not have a quality control provision in their license. So when the time came that they had a entity that was a licensee, but their term had expired and they continued to use the mark, when the bridal shop went to fight and say, you're using our mark and you can't anymore, our license agreement has expired, they came back with, you're not exercising any quality control over these marks. And it ended up hurting the bridal shop in losing their rights. So you want to make sure that you have quality control in your license agreement. And that is the term that I refer to as avoid naked licensing. Definitely not as sexy as it sounds, and it can have very harsh results. So the concept of naked licensing is when you have your license agreements in place, you're controlling the quality control of that license. So some key takeaways is, federal registration is extremely beneficial to you in building your trademark and protecting your trademark. You want to choose strong, distinct marks. Some people might like to have some descriptors to help people know what they're involved in. Like, for instance, at the bottom of our mark, you see patents, copyrights, trademarks, technology, and business law. So when a customer's dealing with us, they know, what we do. However, we have our distinct logo there as well to set us apart. So choose your strong marks, choose available marks. So before you start going down that road of putting in capital and building your business, make sure that you've got the right to use that name. And then once you register, use the mark consistently, use the mark correctly, and renew them when you're supposed to renew them. And doing that, you will keep an indefinite protection on your marks. Police your marks. And if you grant rights to others, be careful in your contracting. And that's it.
Does anybody have any last minute questions for Kim? If so, just pop them in the chat real quick and we'll get them to her. I'm stalling to see if anybody puts any questions in there, but I think you were very thorough. So it looks as though maybe there aren't any more questions.
Great. Well, it was great, doing it while we were going, so it could stay, consistent while we're on the topic. So, and if anyone, my contact information's on here. So if anyone does have any questions, like I said, sometimes with some of these, with your trademark scenarios, they're very fact specific. So feel free, to reach out. And there'll be some information that I want to provide to the BBB that they can hand out as well. One is some links to the U.S. Patent and Trademark site. That one talks about being very mindful of scammers that are out there, and just some links in general to the U.S. Patent and Trademark site, so you can be, familiar with that.